Imagine waiting your entire adult life for an inheritance that was legally yours, only to have a family member swoop in at the last possible moment and try to claim it was already spent decades ago on a loan nobody can prove ever existed. No contract, no notarized documents, just a memo line on a check from 20 years ago. That is exactly what happened to one family in Pennsylvania, and what followed is one of the most infuriating estate battles you will ever hear about. This is the story of how a trust that should have been a straightforward family inheritance became a 2-decade legal nightmare, and how a quiet memo on an old check almost cost someone everything they were owed. Let us set the scene. A grandmother passes away and leaves behind a trust. A legal arrangement designed to protect and distribute her assets to her family after she is gone. Her son, the father in our story, was named as a beneficiary of that trust. But before the trust could be fully settled and the money distributed, the father himself passed away. That is where things get complicated. When a beneficiary of a trust dies before the trust is fully distributed, their share does not simply vanish. In most cases, depending on the specific language of the trust and the laws of the state, that share passes down to the deceased beneficiary's own heirs. In this case, that meant the father's children, his sons and daughters, were now entitled to inherit his stake in their grandmother's trust. So far, this is sad but not unusual. People die, estates take time to settle. Trusts can be complex legal instruments that take years, sometimes many years, to fully administer. But 20 years? That is not just slow, that is an extraordinary delay, and it raises serious questions about how and why this estate administration dragged on for so long. Fast forward to the present. After 2 full decades, the executor of the estate, the person legally appointed to manage and distribute the assets, has finally begun the process of settlement. The surviving family members, including the children of the deceased father, are now supposed to receive their shares. But right at this critical moment, just as the money is about to change hands, the father's siblings, the aunts and uncles in this situation, step forward with a bombshell claim. They say that one of the brothers, one of the children set to inherit, actually owes money back to the family. Specifically, they are claiming that years and years ago, someone gave this brother a loan, and that loan was drawn against his future interest in the trust. Their argument, in plain terms, is this: we already gave you your money. You took an advance. Now it's time to pay it back, and we're going to take it directly out of your inheritance before you see a single dollar. This is where the story goes from complicated to deeply troubling. Because when pressed for documentation, for a loan agreement, for a signed contract, for anything legally binding that would prove this arrangement actually existed, they cannot produce one. There is no promissory note, there is no notarized agreement, there is no formal loan document of any kind. The only thing they point to is a check, an old check, that allegedly has a notation on the memo line indicating it was a loan. Let that sink in for a moment. After 20 years, with tens of thousands of dollars potentially on the line, the entire case for clawing back this brother's inheritance rests on what someone wrote in the memo field of a personal check. Now let us talk about why this matters legally, because this is where the story gets genuinely fascinating from a legal perspective. Pennsylvania, like every other state, has what are called statutes of limitations. These are laws that set strict time limits on how long a party has to bring a legal claim. Once that window closes, it does not matter how valid your claim might have been, you are legally barred from enforcing it. For written contracts in Pennsylvania, the statute of limitations is 4 years. For oral or informal agreements, it can be even shorter depending on the circumstances. The alleged loan in this story was made long before the current push to settle the estate. We are talking well over a decade ago, possibly closer to 2 decades. The statute of limitations on any loan claim expired years, perhaps many years ago. What this means in practical terms is extraordinary. Even if the loan was real, even if everyone agreed that money was handed over and was intended to be repaid, the window to legally enforce that repayment has closed. It is gone. The law does not allow you to simply sit on a claim indefinitely and then spring it on someone when money finally becomes available. There are time limits precisely to prevent this kind of ambush. Now there is another critical wrinkle here. The executor of the estate, the person legally responsible for managing this entire process and making sure assets are distributed properly, apparently had no knowledge of this alleged loan when it was made. She is only hearing about it now, at the moment of distribution, through the claims of interested parties who stand to benefit financially from the outcome. This raises enormous red flags. An executor has what is called a fiduciary duty. That means she is legally obligated to act in the best interests of the estate and all of its beneficiaries, not just the ones who are the loudest or the ones making claims at the last minute, or the ones who happen to be her relatives. She cannot simply take someone's word that a debt exists and start redirecting inheritance funds to cover it, especially not when there is no legal documentation, no court order, and a clear statute of limitations defense available to the person being targeted. If the executor were to honor this alleged loan claim without any legal basis, she could actually be exposing herself to personal liability for breach of her fiduciary duty. That is not a trivial risk. Executors who mismanage estates or distribute assets improperly can be sued and held personally responsible for the resulting losses. So what should the brother do? What can anyone do in a situation like this, when the legal threat feels very real, but hiring an attorney seems financially out of reach? First, do not stay silent. The worst thing you can do when someone makes a claim against your inheritance is simply hope it goes away, or assume the executor will figure it out. Put your objection in writing. Send a formal letter to the executor stating clearly that you dispute the alleged debt, that you are not aware of any enforceable loan agreement, that no formal documentation exists, and that any statute of limitations on such a claim has long since expired. Keep a copy of everything. Second, research the Pennsylvania statute of limitations for yourself. Knowing the law is powerful, even if you are not a lawyer. Many courts have self-help resources, and many state bar associations offer free or low-cost legal consultations. Even a 1-hour consultation with an estate attorney can give you the framework you need to protect yourself. Third, understand that an executor cannot legally withhold or redirect your inheritance based on an unverified, undocumented, time-barred claim made by interested parties. If the executor tries to do so, that action itself may be legally challengeable. You can file a formal objection with the probate court overseeing the estate. Probate courts exist specifically to resolve exactly these kinds of disputes, and you do not always need a lawyer to file a basic objection. Fourth, consider consulting a probate litigation attorney even if money is tight. Many estate attorneys work on contingency in cases where a clear inheritance is being wrongfully withheld, meaning they only get paid if you win. Given the facts of this situation, no documentation, a clearly expired statute of limitations, and an executor who was never informed of the alleged loan, this case may be more winnable than it appears on the surface. The broader lesson from this story is one that every single person who stands to inherit anything should take to heart. Estate disputes do not always look like dramatic courtroom battles over millions of dollars. Sometimes they look like this: an old check, a memo line, and a family member who waited for the most vulnerable moment to make a claim they know you cannot easily fight. The legal system has protections built into it for exactly these situations. Statutes of limitations exist because society decided collectively that it is unfair to hold people legally liable forever on claims that were never properly documented or pursued in a timely way. Time limits are not technicalities, they are rights. And in this case, the brother's right to receive his inheritance appears to be firmly protected by both the lack of documentation and the expiration of any legal window for enforcement. Do not let anyone, family member, executor, or otherwise, convince you that an undocumented claim from 20 years ago is a valid reason to take what is legally yours. If something like this has happened to you, if you are facing an estate dispute, a last-minute claim against your inheritance, or an executor who does not seem to be acting in your best interest, do not navigate it alone. Research your state's probate laws, consult with an attorney, even for just 1 hour, and put everything in writing. You have more legal protection than you might think. If you found this video helpful, please subscribe to this channel. We cover real legal situations like this one every week, breaking down the law in plain language so you know exactly what your rights are and how to protect them. Your next video is already waiting for you.